Hey everybody, Nick Espinoza, your chief security fanatic here, and today we're actually talking about a really interesting case. This is about a blogger in the United States that was court ordered to suppress free speech. This is an odd one, but I think it's really concerning for the future of obviously free speech and the internet as well in terms of platforms for publishing. This is coming from News Observer, and we are going to North Carolina because their Supreme Court ruled 2 weeks ago on this issue, and this is basically, in a nutshell, what they ruled on. Apparently, a judge in North Carolina didn't go too far when he charged and then convicted a blogger of a crime for recording a court hearing, but then he forced that blogger to write a lengthy essay about respect and then post it online and then delete any negative comments that people might write. Now, this case basically is raising concerns about First Amendment freedoms in North Carolina. And here's the history of this. This case all started in 2018 when William Coward, a Macon County judge, criminally charged Devin Elredge, which basically came from a local news site called Trapalacia, for recording a video on his phone from court. Now, there were signs posted in the court saying that no one was allowed to record, but a bailiff saw Elredge recording anyway and told him to stop. He refused, and so the officer told Judge Coward, who then stopped the trial to reiterate his ruling against recording, according to the legal records and proceedings in this later. Coward then charged Elredge with contempt of court and even got the SBI, which I'm guessing is some Bureau of Investigation, involved by giving agents a search warrant that let them gain access to Eldredge's Facebook, including his private messages. Coward then served as the judge overseeing Eldredge's contempt of court charge, which Elredge opposed, saying that Coward should have to recuse himself. The judge refused, saying that he could be impartial. That disagreement formed a large part of Eldredge's appeal after Coward convicted him, but the Court of Appeals in North Carolina let everything stand with this 2019 opinion. Now, basically, the North Carolina Court of Appeals upheld the judge's actions in 2019, but not without one dissenting opinion. The dissent was by Judge Christopher Brooke, who said it was okay for the judge to restrict the recording in the courtroom and find the blogger guilty of contempt of court, but it was not okay to force him to publish an essay on, quote, respect for the court system, and then censor anyone who criticized it. And I quote Judge Brooke, the probation condition imposed by the trial court requiring the defendant to write and publish an essay about respect for the courtroom on his social media and internet accounts and to delete any negative comments made by third parties on this essay bear no reasonable relationship to the defendant's rehabilitation or to his crime and raises serious First Amendment concerns. Now, the opinion 2 weeks ago from the North Carolina Supreme Court was much shorter. It was less than 1 page and simply says the justices affirm the Court of Appeals ruling, meaning basically the original judge was in their right to essentially have him delete what is essentially free speech, and they had no further comment or explanation. So this is deeply concerning, I think, for both the freedom of speech and also for expression online. I would agree, actually, with the dissenting judge here, Judge Brooke. I think it was fine for the original judge to forbid recording, in the sense that already it was posted, no recording in this court. He was breaking the law by virtue of that, and judges have to allow courts to record or not. So, for example, Judge Ito in the OJ trial allowed cameras into the courtroom. He did not have to do that. That was his essential judgment on that. I even think it's okay to punish the blogger for breaking that law by holding him in contempt of court. But what's not okay is deleting opinions that contradict the judge's opinion. So, for example, for a state Supreme Court to uphold this, I think is a rather dangerous precedent for bloggers, social media, and quite frankly, what has now become the public record, which is our social media accounts, is our publishing and all of that. And we are always going to face opinions we disagree with, we don't like, and everything else, whether it is about the institutions in the United States, whether it's about branches of the federal government, including the judicial system, and those opinions should not be censored. I think it's perfectly fine. He needs to write an essay on this about what respect is and what respect means. And, he can write it in any which way, shape, or form that he wants. But for me to basically respond and say, well, I disagree, I don't respect the court system, That's perfectly fine, and that's allowed under the First Amendment. And if this goes to the United States Supreme Court, I would really hope that they would take up this case, because this is possibly setting a precedent for very serious violation. Imagine all of the dissenting opinions you have about your local, state, or federal government that you've posted on Facebook or Twitter or any other platform that you have, and now suddenly we have a legal precedent that says you can't discuss that. That is exactly the antithesis of who we are as a nation from the foundation of the U.S. Constitution. That's a very serious problem. I think this is an issue, and I think we should all be alerted and alarmed, rather, and alerted to the fact that this may fundamentally change how we operate in the United States if other Supreme Courts or the United States Supreme Court agrees with the original judge. This is a very dangerous precedent, and I think it needs to be observed, because fundamentally, we have a lot of freedoms on the internet to say what we want, and private corporations can censor us all they want. We've seen a whole bunch of that, during the last election. But at the end of the day, our opinions are our own, and where we publish or how we choose to publish, may be dependent on the platforms that allow us to. But at the end of the day, we can and we should. And I think this is a very serious topic that opens up a whole bunch of different criticisms, issues, and everything else as we navigate basically the platforms in our own personal publishing online. So I'd be curious to hear your thoughts about this. This one I don't think is going away, and I'm going to be following this one very closely. And I hope that news outlets and more people pick this up than just the News Observer, which I'm guessing is probably out of North Carolina. And here we are, and that is your news of the day. And please like, share, follow me here on Facebook and Twitter at NickAESP, where hopefully you'll always be free to publish. And, then again, we just went through that. And please feel free to subscribe to me at YouTube as well, which again, private corporation. But as always, stay safe and stay online. Thanks, everyone.